addition to mobile phone, one SIM has been recovered, and the custody since 2025. So far as the mobile number is concerned, the one SIM that has been recovered is my possession, and the mobile number of that particular SIM is concerned. The fraud number and my mobile number differs. The number from the fraud has been conducted is 6372, and my mobile number, as mentioned in FIR, is totally different.
Which mobile has been recovered from your possession as per the FIR?
Two mobile phone has been recovered from my possession. That is one green color Vivo Android mobile phone and one brown color Infinix Android mobile phone with Jio SIM.
Where is it mentioned?
In paragraph number 5.
In the FIR.
In the FIR.
Jameel Ansari.
Yes, sir. Green color Vivo mobile phone, IMEI number, brown color Infinix Android mobile phone.
They all belong to you?
Jio SIM number.
They are registered in your name?
The phone belongs to me, the mobile number belongs to me, but the mobile number from which the offence has been committed does not, it's totally different.
So the offence, so from these mobile numbers, offence has not been committed. What is there in the improved order? Let's have a look.
You remember EMI number, that mobile and crime linking is crime linking found number, that EMI number. That
Yeah, IMEI number.
Yeah, IMEI number. Page 18 Malati, technical inquiry crime link were found with the acknowledgement number against IMEI number and mobile number. Recovered from the petitioner showing the online fraud, financial fraud. Further, para so is the appear that the mobile recovered from petitioner as per CFA were being used after getting a false SIM card for the confession statement petitioner.
You say that this mobile is in your name. The SIM card is in your name.
Fake ID card.
Is in your name? Are you sure about it?
No, I'm not sure.
Then how are you making the statement?
The recovery that has been made from me.
Is it in your name?
No.
Then
I'm not having an idea about that.
You don't have an idea and you keep on arguing.
Because the position, the recovery that's.
I want to know whether the mobile number is yours.
No.
The SIM is yours.
I'm not having an idea about that.
It's clearly mentioned that it is not your this.
That I have already been mentioned in paragraph number 1486, and I have been enlarged on bail by the court in relation regarding that.
How many cases are registered against
Only
you?
one case. They were cyber 25 of 2024. I have mentioned that in paragraph number 14. That the petitioner was earlier made accused in Lebanon cyber case number 25 of 2024, in which he has already been granted bail in DA number 4904 of 2024 by the court in Lebanon.
Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case, and the details of recovery made from the possession of the petitioner with regard to mobile number, SIM number, etc. were not used for commission of offence. That's right. She submits that the petitioner is in custody since 2/12/2025. During the course of hearing, the learned counsel for the petitioner has also referred to paragraph 14 of the bail application as stating that the petitioner has one criminal antecedent in which he has been enlarged on bail. The learned counsel for the state has opposed the prayer and has submitted that in the impugned order itself it has been recorded that during technical inquiry, crime link was found with acknowledgement number against IMEI number and mobile number of mobiles recovered ये तो general statement कैसे पता चला recovered from the petitioners
This petition have also recovered.
कहाँ है
Page 41 of the Jamil Ansari, green color, Vivo Android mobile EMI number so and so, and one mobile number also mentioned brown color infinite Android mobile EMI number so and so, जिसमें 0 सिम होगा. Then after that,
नहीं, you see, the bail application of number of persons has been rejected by the same order, and there is no segregation.
but one of the petitioner has not the season list.
Sorry,
Season list has not been one of the
Caesar is not in dispute. She says that these mobiles were not used for commission of crimes.
in doing inquiry, the crime link.
Case diary आ गया?
नहीं.
It is not clear from the impugned order. It is the rejection order is of multiple persons.
Several person have 7 person have arrested matter, and
Yes,
several
right.
person have also found the EMI number with the SIM matter, and during the investigation, crime link has also found.
ये आपका 5 आदमी से रिकवरी हुआ, 5 आदमी से अलग अलग फोन रिकवरी हुआ, किसका मोबाइल से क्या कमीशन ऑफ ऑफेंस है तो क्लियर नहीं है. You file the we call for the case.
Yes, also filed the
Call for the case study and counter 7th April. उतना मत लिखिएगा. Not required. It is not clear from the impugned order. इससे कितना रिकवरी हो रहा है. कोई बात नहीं, आप केस डायरी लेके आइए, आप फोन नंबर दिखाइए, इनका यूज ऑफ कमीशन ऑफ ऑफेंस.
cyber case में आता है हर एक particular number.
Madam, you are very powerful to have the case diary. We are not so powerful. So you have to call for it. ऐसा मत दिखाया करिए केस डायरी कोर्ट में. एक्यूज के पास केस डायरी है, ना कोर्ट के पास है, ना स्टेट के पास है.
वो हाफ जो नीचे कोर्ट में होता है वो
Item 9 DA.10.03.2026 of 2026.
I would say it's a case of commission of faith. Although according to the FIR there is any specific imperative so there is additional members. But it appears from the input order as well as other materials members. The fact remains that the informant in fact wanted to marry her daughter with this petitioner, which was not finalized, to which Melot said the informant put pressure, and on refusal Melot he defeated this case in this case. Apart from that, Melot said the other witnesses during the investigation, it has come कि वो जो है informant party सिर्फ शादी करने के ख्याल से पंचायती करना चाहता था, and not only that Melot said, it also appears कि मोबाइल नंबर जो यूज किया गया है always कॉल जो आता था on the side of the informant, not by this petitioner.
Not a case.
And kindly have a look to the annexure 2 matter.
There is direct allegation against him.
लेकिन उसके बावजूद भी the occurrence firstly occurrence took place on 21/10/2025, but the FIR was lost after a delay of about 2 months on 1st of December 2025. और उस पीरियड में ये किक मार, and all these things has come in the case diary itself. Apart from that, my lord, may kindly have a turn to page, relevant page is at 26. The informant, being a major lady, my lord, said, took a benefit of Manrega scheme, which was given by the state authority. My name is, the name of this victim was found placed at serial number 120.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that it appears that the informant, who is the mother of the victim, wanted the petitioner to marry her daughter.
Yes.
But when it did not materialize, the FIR was filed. He also submits that the FIR has been lodged after delay of about 2 months.
About 2 months.
The learned counsel for the respondent has opposed the prayer. Opposite
And the
party has
victim-
opposed the prayer. And
Victim is major. According to the annexure 2 matters. According to the annexure 2 matters. Nothing else.
the learned counsel has also submitted that the victim is major as per annexure.
Annexure 2 matters.
Two क्या है?
ये जो गवर्नमेंट का स्कीम है मैया सम्मान योजना एंड दैट बेनिफिट इज
As the victim is taking the benefit of Manrega
मैया
सम्मान योजना.
योजना.
The learned counsel for the opposite party has opposed the prayer and has submitted that the victim is minor as per the matriculation examination. Her date of birth is shown as 1/1/2008. Victim is minor. This court finds that there is direct allegation against the petitioner. And she has supported the allegation. Accordingly, this court is not inclined to enlarge the petitioner on bail. Dismissed.
Yes, this is statement.
It is always at this stage.
No. The case is running for evidence matters. So some time will be given so that the case will be decided either.
How many witnesses have been examined?
There are perhaps eight.
How many have been examined?
And the first witness will be coming by tomorrow.
कोई बात नहीं. Next.
Item 10, DA.10.03.2026. or 1026.
No time is required. What is the stage of the case? How many witnesses have been examined?
6 witnesses.
How many left?
7 witnesses have been examined.
How many left?
3 judges.
Must be official witnesses.
But the status will be got for it.
Not required.
But if
You produce all the witnesses.
But senior counsel is
Not-
in the Singh Singh would be appearing in this matter.
Like,
He's
आपने
on
टाइम
this.
नहीं मांगा था शुरू में.
But he's
No,
on
no.
this time.
No.
But I was only praying to file
No.
this supplementary.
लाइए ना, दे दीजिए. इसमें प्रेइंग का क्या है? You
We could
give
not
it
file it
first.
because of the 48 hours you get given.
There is no such difficulty. You can always ask the court master and deal with it. सब हॉस्टाइल हो गए?
Well, most of them informant has. But sorry for passing for 2 cases.
No. You did not seek an adjournment at the
Well,
judge. BA number 1289 of 2026.
he's on legs, man. So he-
The learned counsel for the parties are present. The counsel for the petitioner submits that the bail application of the petitioner has been rejected twice by this court. Once in BA number 7201 of 2024, white order dated 21/11/2024, and thereafter in BA number 2672 of 2025, white order dated 4/4/2025. There are serious allegations against this court. He has filed a supplementary affidavit before this court and has stated that out of how many witnesses?
10.
Out of 10 witnesses, 7 witnesses have already been examined. This court finds that there are direct and serious allegations against the petitioner, and the trial is at advanced stage. And accordingly, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses. The counsel for the state is directed to communicate this order to the appropriate authority.
Time frame may be fixed so that
कोई
they
time frame नहीं है
can.
उसमें।
Only my humble request. The name
तीन
of
लोग मत।
but the name of the senior counsel may be recorded. He has been engaged in
नहीं,
this
ये
matter.
सब ऑनलाइन प्रोसीडिंग्स है, इसमें ऐसा नहीं हो सकता।
And he was on legs.
देखिए, पास ओवर का प्रेयर हम तुरंत कर देते हैं। बहस करने के बाद जब हम बिना
for time, Alex. Initially, I paid for.
Item number 11, DA12.09.2026.
it can't be. तो सेग्रीगेट करते हैं, सेग्रीगेट तो नहीं होगा ना। 5 kg is too much, not a case for bail.
Intermediate quantity is there is blood. It is much less than the blood. One.
Not a case for bail. NDPS.
Blood intermediate quantity it is blood much less than
5 kg is intermediate quantity.
My limited knowledge. Blood 1 kg.
What limited
1
knowledge?
kg is more quantity, 20 kg is
Commercial to 1 to 20 is intermediate quantity. Blood. I am in custody since blood 5 months. Charges has also been made. But at least diary may be required for.
Not required.
Blood charge sheet has been
Not
also.
required.
I
BA
am-
number not required. BA number 1299 of 2026. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that there has been recovery of 5 kg of ganja from the joint possession of number of persons, amongst them the petitioner is one of them. The learned counsel submits that the recovery is of intermediate quantity and the petitioner is in custody since
17/10/2025.
17/10/2025. Charge sheet has been submitted and charge has already been framed. Any antecedent?
No antecedent, paragraph 16. Out of 14 charge sheet witnesses, not even one has been examined till date.
He submits that out of 14 charge sheeted witnesses, none has been examined so far, and charge has been framed on
3/1/2026.
on 3/1/2026. The learned counsel for the state has opposed the prayer and has submitted that summons have been has been issued for examination of witnesses, and the state will ensure prompt production of witnesses so that the trial is concluded at the earliest. After hearing the learned counsel for the parties and considering the direct allegation against the petitioner regarding recovery of total 5 kg of ganja along with other co-accused, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses. Communicate.
Item 12, DA1301 of 2026.
Also, the requisition is about of section 103. The informant of the FIR. The informant is कहीं भी वो प्लेस ऑफ ऑकरेंस पे नहीं है. Informant मामा है मिस्टर डिसीजन. और से उनके
FIR. आप कौन हैं? आप डिसीज कौन हैं? हस्बैंड. शादी कब हुआ?
2008 का 4 बच्चे भी.
Have you?
Child witness of the deceased says that in order matter, this petitioner and others family members resulted in apartment created.
कोई रिकॉर्ड नहीं है बाकी चाइल्ड रहा है। ये केस डायरी अब 14 में ये खुद बोल रहे हैं कि हम लोग सोए हुए थे और वो खुद बता रहे हैं कि जो इन्फॉर्मेंट है उन्होंने बताया कि हमारे माता को मार दिया है। और जो अदर फैमिली मेंबर्स हैं वो डिस्चार्ज हो चुके हैं पहले ही में। इन पैरा 14 एंड 15 कोई प्राइमा फेसाई केस में कॉप नहीं होता।
आपके ऊपर डायरेक्ट एलिगेशन है।
Yes, Lordship, direct allegation है but वो present ही नहीं है वो at the place of offense।
कहाँ एलिगाई का
No, informant वहाँ पे है ही नहीं Lordship। वो just
ये जो बच्चा बोल रहा है
नहीं, यही तो कहना चाह रहा हूँ मैं कि ये कोई रिकॉर्ड में नहीं है।
चाइल्ड विटनेस हैज बीन एग्जामिन्ड, व्हाट इज द
कोई आई विटनेस चार्जशीट में फाइल हो चुका है मैम और कोई विटनेसेस भी एग्जाम
चार्जशीट का फाइल आप कब से कस्टडी में
कस्टडी में 18/12/24 और चार्जशीट फ्रेम को हम 19/6/2025 कोई विटनेसेस एग्जाम नहीं और केस डायरी में सिर्फ सजेस्ट कर रहे हैं कि जो बच्चे हैं वो खुद बोल रहे हैं कि हम दोनों सो गए थे। पैरा 14 एंड 15
ये आप क्या दिखाना चाहते हैं?
केस डायरी
आपके पास बड़ा अच्छा है केस डायरी में। आप लोग सारे कोर्ट में अपना अपना केस डायरी दिखाते हैं क्या? हमको नहीं पता हमारे हाई कोर्ट का प्रोसीजर बदल गया है क्या? पिटिशनर ही केस डायरी प्रोड्यूस करता है कोर्ट में आजकल पिटिशनर केस डायरी प्रोड्यूस करते हैं कोर्ट में। ऐसा कोई लॉ चालू हो गया क्या? केस डायरी अपना मत दिखाया करिए।
और इंडिपेंडेंट विटनेसेस जो है इसमें वो भी नहीं कह रहे हैं।
हस्बैंड का क्रिमिनल एंटीसीडेंट भी होता है क्या? वाइफ के मर्डर का कैसा बहस करते? हस्बैंड का केस है, वाइफ मर गई है, क्रिमिनल एंटीसीडेंट, इसका क्या रेलेवेंस है रेलेवेंस है कोई रेलेवेंस? हस्बैंड का क्रिमिनल एंटीसीडेंट पढ़िए, एफआईआर पढ़िए तो सर। Who is the informant? The father of the deceased?
Case plus one, brother of the deceased.
Brother. पढ़िए।
निवेदन पूर्वक सूचित करना है कि मैं मुकेश पासवान, पिता श्री प्रयाग पासवान, स्वयं मेरी बहन संजू की शादी रामदेव पासवान, पिता दशरथ पासवान, साकिन सरिया, स्वयं अप्रैल 2008 में हिंदू रीति रिवाज के अनुसार हुई थी। शादी के बाद मेरी बहन ससुराल में गई और अपने पिता और के दंपत्ति में रहने लगी। पति के दंपत्ति में रहने लगी। इन दोनों के वैवाहिक संबंध में 4 पुत्र, एक अरविंद कुमार, अजय कुमार 9 वर्ष, प्रवीण कुमार 7 वर्ष और गुड्डू पासवान 3 वर्ष। मेरे बहनोई रामदेव पासवान डीजे बजाने के काम करते हैं और विगत 6 माह पूर्व से मैं मेरी बहन को अपने बाप से 50,000 रुपए की मांग को लेकर दबाव बनाते और कहते थे कि यदि रुपए का इंतजाम नहीं करोगे तो तुम्हारा बाल बच्चा का जीवन दयनीय हो जाएगा। जब मेरी बहन मृतिका संजू देवी उक्त मांग को लेकर हमारे परिवार को बताई, किंतु हम लोग की आर्थिक स्थिति कमजोर रहने के कारण उपरोक्त लोगों का मांग पूरा नहीं कर पाए। मांग पूरा नहीं होने पर मेरी बहन की सास फुलवा देवी, पति दशरथ पासवान, अक्षय कुमार पासवान, दीपक पासवान दोनों, पिता दशरथ पासवान, गोतनी सुधाता देवी, पिता अक्षय पासवान, सभी ग्राम सरिया निवाड़ी, थाना स्वयं मिलकर मेरी बहन संजू देवी को यातना देते थे एवं नाना प्रकार के नाना दिया करते थे। मेरी बहनोई रामदेव पासवान भी अपने परिवार वाले के साथ मिलकर मेरे बहन का उनको यातना देते थे। इस बाबत हम लोग के द्वारा हम लोगों को काफी समझाया गया, लेकिन वे लोग मानने के तैयार नहीं। दिनांक 12/12/24 को मैं अपनी बहन के ससुराल गया और कुछ दिनों के लिए अपने घर मायके लाने का प्रयास किया, किंतु उसके ससुराल वाले विदा करने से मना कर दिए। दिनांक 14/12 को तड़के सुबह 4 बजे दीपक पासवान के द्वारा मुझे मोबाइल के द्वारा सूचित किया गया कि मेरे भाई रामदेव पासवान की तबीयत खराब है, आप तुरंत आ जाए। मैं और मेरी भाई रजनाथ पासवान सुबह समय करीब 7 बजे ग्राम नावाडी अपने बहन संजू देवी के ससुराल पहुंचे तो देखा कि मेरी बहन अपने सैन्य कक्ष में मृतक अवस्था में पड़ी हुई, गला पर दाग और जख्म का निशान पाया। जब बच्चे से पूछा किया तो मेरे भगना प्रवीण कुमार उम्र 7 वर्ष ने बताया कि पिताजी एवं चाचा चाची एवं दादी सभी मिलकर मेरी मां के साथ मारपीट की है और पिताजी
गला दबा दिए, गला दबा दिए, हम लोग ओपनिंग को सभी चारों घर से भरा।
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is the husband and the informant and the FIR has been lodged by the brother of the deceased who is not an eyewitness of the occurrence.
the statement taken from the child is the minor child.
That's it. The learned counsel has also submitted that
And
the
the above जो कि
कोई
9 साल का और 14 साल का है, उसका स्टेटमेंट इनकंसिस्टेंट
कोई बात नहीं. The learned counsel has also submitted that when the informant, as per the FIR, when the informant reached the place of occurrence, all the accused persons had fled away, and statement upon the statement of one of the child of the petitioner, who stated that his father, uncle, aunt, and grandmother all had assaulted the victim, and the petitioner had pressed the neck of the mother, and she was found dead. The learned counsel for the नहीं, ये बीच में घुस के क्या कर रहे हैं? बैठ जाइए प्लीज. This court finds that there is direct allegation against the petitioner, and that's it. And this court is not inclined to enlarge the petitioner on the rejected.
Item 13, DA.13.08 of 2026.
Yes, please.
Page number 13, madam.
Yes.
तो अब इन्हें निवेदन है कि मैं शांति देवी उम्र की 40 वर्ष पत्नी कल्लू राय रामपुर बिहार थाना बोरिया जिला गोड्डा का रहने वाली है। मेरी लड़की निर्मा कुमारी उम्र 16 वर्ष सुबह दिनांक 17/1/25 को घर से 7 बजे से बात बोलकर निकली। जब वो लौटकर घर नहीं आई तो हम लोग खोजबीन करने लगे। खोजबीन के क्रम में पता चला कि मेरी बेटी निर्मा कुमारी को प्रवीण राय पिटिशनर जिला बांका बिहार शादी के नियत से माला बुलाकर बनाकर ले गए हैं। हम लोग खोजबीन के कारण विलंब से आवेदन थाना में दे रहा हूँ। ये FIR 21 दिन के बाद लॉन्च हुआ। इसका स्टेटमेंट है कि उसी समय 2 घंटा 3 घंटे के अंदर मालूम हो गया है कि पिटिशनर लेके गया है। इसमें 3 विटनेस एग्जामिन हो चुका है। सबसे पहले विक्टिम का ही पढ़ देते हैं। व्हाट इज डिपोजिंग, दैट इज पेज नंबर 50 एनेक्सर 2/1। घटना दिनांक 17/25 की है। घटना के समय में कक्षा 9 की छात्रा थी। मेरी जन्म तिथि 12/6/2008 है। मैं अपनी मर्जी से घर में बिन बताए प्रवीण राय के साथ चली गई थी।
प्रवीण मेरे घर के तरफ आता जाता था, इसलिए जानती हूँ। मैं प्रवीण के साथ उसके घर सिंगापुर गई थी, उसके बाद सिंगापुर से प्रवीण के साथ मैसूर चली गई। वहाँ करीब 2 माह तक उसके साथ रही। मैं प्रवीण के साथ घर आ गई। थोड़िया हाट में पुलिस मुझसे मिली थी, उस समय प्रवीण भी मेरे साथ था। पुलिस हम दोनों को पकड़कर थाना लाई थी और मुझे धारा 183 PLS के अंतर्गत बयान के लिए मजिस्ट्रेट के समक्ष ले गई थी। तत्पश्चात मेरा बयान भी हुआ था। यही मेरा बयान है जिस पर मेरा हस्ताक्षर है, बनाती हूँ। पुलिस मुझे चिकित्सीय जांच करने के लिए चिकित्सा पदाधिकारी के पास ले गई थी। वहाँ मैंने अपनी मेडिकल जांच कराने से इनकार कर दिया था। मदर भी बोल रही है कि क्योंकि बिना बताए घर से चली गई, PW3 मैटर, वो भी एग्जाम में हुई है, इसलिए हम केस कर दिए।
Victim is minor, madam.
Yes.
And फिर जैसा 16 देख लिया जाएगा जो विक्टिम का है। मेरी उम्र उस समय 18 वर्ष से ऊपर थी। मैं घर से बिना बताए अपनी मर्जी से निकली थी। इस केस में प्रवीण का कोई गलती नहीं है, वह बेकसूर है। भाई भी यही बोल रहा है, क्योंकि बिना बताए गई थी इसलिए हम लोग केस कर दिए। इन्फॉर्मेंट भी वही बोल रही है कि बिना बताए गई थी इसलिए हम केस।
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the victim was found missing, and in the FIR itself it has been alleged that the petitioner who is age बताइए 21 years of age had taken the victim. He submits that there is a delay of lodging FIR by 21 days. He has also submitted that the victim has been examined before the court, wherein she has stated that she had himself eloped with the petitioner, and during her cross-examination she has stated that she was 18 years of age. She was more than 18 years of age at the time of occurrence. And she also refused to undergo medical examination. The learned counsel for the state has opposed the prayer by stating that the petitioner, the victim is a minor.
Yes.
Study about 1 year. This March 2025.
The learned counsel for the petitioner has submitted that the petitioner is in custody since
This March 2025.
23-20. After hearing the learned counsel for the parties and considering the aforesaid submissions made on behalf of the petitioner, and also the age of the petitioner, who is 21 years as per the bail application, and that the victim has herself stated that she had gone with the petitioner suo motu and all by herself, and she also refused medical examination. The petitioner is addicted to paper assembly.
Item 14 DA.13.03 of 2026.
In this case of robbery matters, 4 unknown persons have given effect to their evidence, and the of the petitioner surfaced at a later stage on the completion of the hearing. Except the completion of the hearing, there is no other material against him. Whether he is deemed not just an education grade, or there is anything established his access to the post office.
Antecedent तो इसमें ऑर्डर में लिखा
No,
हुआ
that is
है.
against the other co-accused.
This is against
Study.
call for case diary, criminal antecedent report, counter statement by counter. 17.
Item 15, BA 1030 of 2026.
FIR law. So there is a delegation that 1.317 is FIR. When a phone call was received by the informant, may read law. मेरा नाम अनकोट मोशन सेक्शन 6 सेक्शन 6 आज बिना निकला मेरे आशीष मंडल 28 में मकान करता हूँ तो कैलाश कुमार पांडे जिला पॉपुलर थाना में आता है कंप्यूटर आवेदन दिया गया इसमें उनके द्वारा मोबाइल नंबर सचेत से को फोन का हल करना मैदान बुलाकर दो लोगों द्वारा गाड़ी प्रवेश करते आवेदन गोरखपुर के मुकदमा को समाप्त कर लेने का नहीं करने पर गोली मार के दिल्ली में गाड़ी धमकी देने का आरोप लगाया गया था. This is the allegation. On this mobile number was searched. The mobile belongs to
Some other case was pending.
no, sir. I know that the mobile belongs to Bhagwan Mandal and that was used by Ashish Mandal. Ashish Mandal has been granted when I managed Ashish Mandal has stated that I ran from that mobile to that person.
दो लोगों द्वारा गाली गलौज करते हुए आवेदक द्वारा पूर्व में किए गए एक
It is
मुकदमा.
not clear, Lord Sir. I am no Lord Sir. It is the mobile belongs to Bhagwan Mandal. Bhagwan Mandal is saying that the mobile was used by Ashish Mandal. And Ashish Mandal's house was searched. What armed was received from the house of Ashish Mandal and Visu Uttarankar. Ashish Mandal confessed that I ran from that mobile to that person. This is the allegation.
ये जो पूर्व में दिए गए मुकदमा का क्या
और
कहानी?
जो हम भी नहीं कर सकते हैं तो हमें इसमें एक पैराग्राफ लिखे हैं कि पूर्व में ये मुकदमा 2013 का कोई केस पेंडिंग है, लिखे हैं पैराग्राफ 7 में. पैराग्राफ 7 में स्टेटेड 2013.
This is threatening the witness.
Not that this is not the case because only on the confessions of Ashish Mandal मोबाइल हम मेरा है ही नहीं और इसमें मेरा कोई एंटीसीडेंट नहीं है और I'm because जो कोई क्यों स्टाफ बने सब bail order लॉस केस 20 तो accused person है
चार्जशीट हो गया आपका?
मेरा चार्जशीट नहीं हुआ इन्वेस्टिगेशन चल रहा है इनके आशीष मंडल और विशु कर्मकार में 20
आपका चार्जशीट नहीं हुआ ना?
20 से 26 तक तो नहीं हुआ अभी आज प्रेजेंट
चार्जशीट होने चाहिए.
सूचना के सत्यापन में जब पुलिस पार्टी जब गई तो जज साहब तो मंडल
इसमें इनका वो लाउड स्पीकर क्यों नहीं चल रहा है? सभी जेलों का लाउड स्पीकर काम नहीं कर. ऑन कर.
सूचना के सत्यापन में बेंगली पुलिस पार्टी reached the Ashish Mandal's house and Visu Karkar present on the place of where the recovery was made. The alleged arms were recovered and on the instance of further inquired by these two persons, they have disclosed the name of this petitioner. This is the allegation in page 17 in bottom and first portion of page 18. 17 का bottom में आया तो 18 में first में और इनकी नोट के ऊपर आया है.
केस उठा लेने का आप धमकी देते हैं.
हम बोल रहे हैं कि स्पेसिफिक हम बोल रहे हैं इस पे हमको नहीं पता हो सकता कि जारी सबमिट ये 86 सबमिट हो गया क्योंकि 20 से 26 का ये रिव्यू ऑर्डर है 21 से 26 का भगवान ये जो गाड़ी भगवान ये काम है जहाँ तक हम अभी इंक्वायरी नहीं किए बता कर लेते हैं या तो उसको करते हैं चाहे सबमिट हुआ है कि नहीं मेरे अगेंस्ट नहीं है उनका फोन से हम मतलब कि आम से मेरे हाथ कोई रिकवरी नहीं होगी काम से लगेगा मेरे अगेंस्ट में मैक्सिमम वाले के जो बोल रहे हैं कन्फ्यूजन नहीं उनके मोबाइल से हम से अभी 2013 का कोई केस उठा रही थी
At your instance, they had threatened. That is the allegation.
no allegation
Yes, that is the allegation. That at your instance, they had threatened.
allegation is that I ran from that mobile
Allegation ये नहीं है कि आपने रिंग किया. That is not that. हाँ. At your instance, they were threatening.
This is the confusion.
This is the allegation.
This is the confusion.
Whatever it is, but this is the allegation.
But
That at your instance, they were threatening the.
I did nothing, Lord. It is a confusion of the poetry that poetry has been done.
Is there any case running between you and the informant?
That I can't say, Lord.
You have said so. You said so that you have stated in your bail application also that there is a case of 2013.
Yes, Lord. But I don't know whether it is against me or not.
You don't know that whether it is against you or not.
Lord, sir,
You are no. You do not know in this case you are accused or not.
I have said that.
Where is your statement?
Yes, but I have said it, Lord. 2013 के केस में 2026 में हम की देंगे.
अभी गवाही चल रहा होगा ना?
नहीं ऐसा है कि 400 सबमिट करके हमको इंक्वायरी कर इसको से पासो फॉर डे क्या है हम इंक्वायरी करने जा रहे हैं.
पासो फॉर डे से तो मतलब नहीं.
And I don't have any interpretation.
हो जाए. किसका किसका मेल हुआ?
इसका भी निश्चित रूप देखा जाए दोनों इसका आम से आम से सब उसका बेल हो गया.
He is 19.
आशी को विशु करने का होगा.
Heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petition has submitted that the mobile numbers through which the call was made does not belong to the petitioner. And it belongs to one Bhavan Mandal, which was used by Ashish Mandal to threaten the informant. The learned counsel submits that Ashish Mandal and Vishu Kankar, who are the male assailants, have been enlarged on bail by coordinate bench of this court. She has submitted that the petitioner is in custody since
9/1/26.
9/1/2026. An investigation against the petitioner is going on. The petitioner has also, the counsel for the petitioner has also referred to paragraph 7 that the co-accused Ashish Mandal had stated that he had threatened the informant in connection with one case which is pending since 2013. The learned counsel for the opposite party has opposed the prayer and has submitted that it was at the instance of the petitioner that the two co-accused persons had threatened the informant of the case in connection with another pending case. And therefore the case of the petitioner is on different footing. A.
Yes, they have to tempted me to not to contest this case. Therefore, on they have called it indifferent and threatened the informant. This has come in
The learned counsel has also submitted that at the instance of the petitioner, they had threatened the informant of the case
yes.
in connection with the earlier pending case. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, that it was at the instance of the petitioner the informant was threatened, and it is not in dispute that there is a pending case since 2013. In view of the aforesaid allegation, this court is not inclined to enlarge the petitioner on bail. At this stage ही रहता है, आप आइए बाद में आइए। विटनेस को इंटरफेयर करने का परमिशन नहीं, 2013 का लेकर आइए। विटनेस को आप थ्रेटन नहीं कर सकते।
Item 60, DA.10.03.2026 of 2026.
Part was in front of Hotel Sangam, and after 10 minutes he came back and found missing his motorcycle. And the fire was
The motorcycle was missing.
lost. The fire was out against someone else.
Recovery?
Recovery only if earlier case was Nimia Card 70 to 2025. And that case Lordship, Kishun Mandal has been arrested and on his confession, said motorcycle was recovered. Thereafter, Lordship, my name has transpired in that case, Nimia Card 70 to 2025, on the basis of confessional statement of Kishun Jadar Lordship, and that case Lordship, I have been granted bail Lordship. And thereafter,
इस केस का मोटरसाइकिल किसके पास है?
70 में हुई मेरे से रिकवरी हुआ 70 में निमिया घाट 70 में मुझसे के रिकवर हुआ था कुछ और मुझसे था किस्म के कन्फेशन से
भाई इस केस में जब मोटरसाइकिल चोरी का एलिगेशन लगा तो
इसमें अभी इस केस का जो मुझसे था से वो केस निमिया घाट 70 में रिकवर हुआ 70 में और उसके बाद इस केस में
तो 70 में भी चोरी का एलिगेशन था क्या एलिगेशन? दो केस एक ही चीज के लिए
14 motorcycles were
14 मोटरसाइकिल्स
14 motorcycles.
से निमिया घाट में एक अननोन थेफ्ट के लिए मुझसे के रिकवरी के लिए केस को किस्म ज्यादा के कन्फेशन से रिकवर हुआ उसके बाद फिर हमको उस केस में किस्म के कन्फेशन में
So you are an accused in that case?
that case and he that case also I have been granted bail.
How many cases are there
वही
against you?
निमिया घाट 70 में there are no any cases registered or before निमिया घाट 70 to 125 उसके पहले
आपके अगेंस्ट में कितने केसेस हैं? तो
निमिया घाट 70 के पहले वो केस
पहले नहीं बाद में बताइए।
बाद इस केस में हमको रिमांड किया गया और इस केस में और ये केस में रिमांड किया गया 70 के बाद 70 में 70 पहले भी
70 में after you have multiple cases against you.
नहीं 70 में 70 में हम लगाए हुए हैं और से 70 में नशा कुछ भी लगाए हुए हैं पेज नंबर 30 confession के सिवा और से there are no any implementing article have been recovered from my possession or and no any relevant documents says that I have been involved in each and every case इसी में मुझे मेरे को कंसर्न हो आई में अपडेट बॉक्स
ये जो निमिया घाट पीएस केस में जो रिकवरी हुआ है वो आपसे रिकवरी
नहीं हमसे नहीं हमने ऐसे टू भी लगाए हुए पेज नंबर 30 पेज नंबर 30 because submitted the petition as report from criminal incident it was further submitted the charges have been submitted for free ground documents और उसमें हम unknown person during the course of investigation petitioner was apprehended and two external motive was recovered in front of his house में हमसे क्वेश्चन पूछे इसी से क्लियर है केवल कन्फेशन पे मेरा नाम आया था और उसी कन्फेशन के ग्राउंड पर इसने हमको रिमांड कर
जेल और सेक्टर जो है वहाँ उसमें 70 में पाया गया, तो 70 में उसके सीज हुआ, उसमें ये मुश्किल हो पाया किसमें ज़्यादा विकास है।
आपको क्या बोलना?
मेरा किसी तरह को
ये बोलना है कि कंसेशनल स्टेटमेंट स्थापना है,
उसके सिवा कुछ नहीं।
After hearing the learned counsel for the parties, the counsel for the petitioner submits that there is allegation of theft of motorcycle. From the theft of motorcycle by the petitioner, he has submitted that the motorcycle was recovered in another case numbered Nimiaghat PS case number 70 of 2025. And in the same case, the petitioner became co-accused on the basis of confession statement
और किसमें ज़्यादा
of
किसमें ज़्यादा
Kishnu
किसमें ज़्यादा
Kishnu Yadav of another co-accused. The learned counsel submits that the petition has already been enlarged on bail in Nimiaghat PS case number 70 of 2025 in DA number 10137 of 2025. The counsel for the opposite party has opposed the prayer and has submitted that the petitioner has confessed his guilt. After to this, the counsel for the petitioner has submitted that the petitioner is in custody since 7/8/2025.
7/8/2025.
Since 7/8/2025, and has also submitted that he has got no other case except the present one and Nimiaghat case number 70.
निमिया घाट 70-25 के पहले उनको केस उसके बाद जो डिमांड किया
किसमें किया गया है ना?
किस में और किया
एक केस में और किया गया.
इसी के बेसिस पर
छोड़ दीजिए last sentence. After hearing the learned counsel for the parties and considering the fact that the petitioner has already been enlarged on bail in Nimiaghat PS case number 70 of 2025, where the motorcycle involved in this case has been recovered from the confession statement of co-accused in the same case. The petitioner is under the custody of the petitioner since 7/8/2025. The petitioner is directed to be enlarged on bail.
Item 17 DA.10.03.2026.
In this case, there are three accused persons, including the petitioner. The allegation under section 414, 468, and 34 of the IPC. The prosecution case note as per the first information report, page 15. The allegation is not in course of vehicle checking. One person, Raju Nayak, accused number 1, was arrested with a motorcycle. He could not produce any document in support of the motorcycle. That was a stolen motorcycle, and then he confessed before the police. Not in the affair itself, it has been disclosed. He confessed and named two persons, the petitioner being the accused number 2, and another Ajay Kewar, the petitioner accused number 3. And on the basis of his confession, then one motorcycle was also recovered from the house of the petitioner. This is not the allegation. Now the charge sheet has already been submitted. Evidence has been taken, and the petitioner is in custody since 11/20. He has three other cases.
Since 11? Custody since?
Custody since 11/12/2025. He moved this on court in antecedent which was rejected.
You have not only criminal antecedents, but
But
there is recovery from your possession.
Recovered not this, the motorcycle in question which is involved in this case is recovered from the accused number 1, Raju Nayak. That is still not.
That's right.
You have just see the
But
page 15.
what has been recovered from your
Then
possession?
he disclosed that I along with other two persons involved in the stolen motorcycle. Then not on the basis of his confession in absence of the petitioner, another motorcycle was recovered. The police suspected
Recovered from your house?
From my house.
Yes,
That
which was also a stolen motorcycle.
That is not said, but nothing has come.
Seizure is there from your from
yes,
your house.
Seizure from my house. The other residents are there. Now you also may kindly see that even not it is a magistrate fact. The petitioner is any surety or security not your also may, so that the only ground for which the petition prayer of the petitioner rejected that he may flee away. That is the only ground. But for that purpose, not the also may kindly see the last paragraph page 21 of the impugn order.
You have been arrested after process under section 82.
Yes. I preferred it with anticipative bail. Thereafter it was rejected. Then
you did not surrender.
Did not surrender. Then I surrendered.
That's right.
Now I remained in custody.
That's right.
Remained in custody. Police submitted charge sheet.
आपके पास रिकवरी है सर?
रिकवरी तो जो मेरे पास इस केस का नहीं है.
इस केस का नहीं है, लेकिन आपके पास स्टोलन मोटरसाइकिल का रिकवरी है ना?
दूसरा केस में तो हम इन्वॉल्व थे, उसमें तो बेल में, तीनों में बेल में. I have stated in paragraph 10 that I was granted bail. Now on the only ground that I may.
This particular motorcycle.
इसके लिए हम हमारे पास रिकवर
नहीं. FIR में तो एक मोटरसाइकिल है.
एक ही मोटरसाइकिल.
उसके बाद 2 मोटरसाइकिल का चोरी का रिकवरी हुआ. एक का आपके यहाँ से रिकवरी हुआ. उसका क्या दूसरा FIR है? कौन सा FIR है?
ये तो नहीं आया. ये नहीं आया. लड़की में काइंडली appreciate that the ultimately what it is the ground which has been taken by the London court that since 82 was issued and I may flee away.
Yes.
Therefore not this it is a magistrate fact.
काफी कोई बात नहीं सर मुझे. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the name of the petitioner, as per the FIR itself, the name of the petition has transpired in the confession statement of the co-accused, namely Raju Nayak. And upon his confession statement, another stolen motorcycle has been recovered from the house of the petitioner. The learned counsel submits that the petitioner is in custody since 11/12/2025. During the course of hearing, the learned counsel has submitted that the petitioner has 3 criminal cases against him.
And I am on bail on those 3 cases.
And he is on bail in those 3 cases. The learned counsel for the state has opposed the prayer and has submitted that stolen motorcycle has been recovered from the possession of the petitioner from his house. After hearing the learned counsel for the parties and considering the facts and circumstances, and that one stolen motorcycle is alleged to have been recovered from the house of the petitioner, and the petitioner also has criminal antecedents totaling 4 in number, including the present one of similar nature. This court is not inclined to enlarge the petitioner on bail. Sir, at this stage you
like the other major offences.
Repeat offences, same nature का repeat offences.
Repeat है तो
कोई बात नहीं, किसी का तो ट्रायल होने दीजिए अच्छे से.
Automatic ये 1342 और 2026.
साल 2 साल नहीं लगता.
23 का केस है और 3 का डिसीजन पे है. आज भी नहीं ट्रायल हुआ.
तो उसमें तो आप मजा ले रहे हैं. इसका ट्रायल जल्दी से कराइए. Yes, please. Why do you need to file supplementary? Sorry? Informant has become hostile. Who is the informant?
Father of the APDCs.
What is the date of marriage? Who are you? You are the husband? What is the date of marriage? 22 to 25. What is the date of death? FIR कब का है? Sorry?
32/5/2021.
तो 6 महीना के अंदर ही खत्म कहानी. Yes. What is the cause of death? FIR पढ़ी. आप नेम दें. Accused named accused होंगे FIR में. पढ़ी. हम लोग जब बेटी के ससुराल के घर के अंदर जाकर देखे तो अपनी बेटी को अंग भंग और मृत अवस्था में पाया. उसके गर्दन में दुपट्टा लपेटा था. उसके उपरांत हम लोगों को Further and council opinion on behalf of the parties. During the course of hearing, it transpired that the victim was married to the petitioner on 22 to 25, and she was found dead in her matrimonial house on 31/5/2025. This court finds that there is direct allegation against the petitioner. This court is not inclined to enlarge the petition on bail against
Item 19 PA 1356 of 2026.
सब तो लिखा ही है यूपी ऑर्डर में. क्या देखना है?
It has come in case that there was fight between both the parties.
What is the age of the victim?
7 years.
How many years?
7 years.
काफी है. इसके लिए केस डायरी की जरूरत नहीं. पढ़िए. Read it.
सभी निवेदन के
Heard the learned counsel opinion on behalf of the parties. The petitioner is named accused and the age of the victim is 7 years. There is direct allegation against the petitioner. This court is not inclined to enlarge the petition and they rejected.
Item 20 PA 1365 of 2026.
Sorry? Who is the arguing counsel? When will he come? When will he come?
Today only.
Tomorrow? Who's tomorrow? चलिए next. At the request of the counsel for the petition, pose this question.
Item 21 PA 1366 of 2026.
Petition.
Okay, I am not for the official section 191, 191
152, 172, 351, 3 और BLS. So bail is 109 corresponding to 306 of the act. You pay 13 lots of cost.
FIR.
Pays 13.
Are you named in that time?
Yes. There is a land dispute between both the parties. Both are the co-aggregate lots of both. Here is the case and counter case. Within 5 minutes, two cases have been launched. One by this informant and another by the wife of this petitioner.
But
Pays 13. सभी निवेदन के साथ अनुरोध पूर्वक कहना है कि मैं लालू यादव पिता स्वर्गीय स्वयंसु आज दिनांक 26/9/2025 के सुबह 4 बजे जब सपरिवार अपने घर में सो रहे थे, अचानक दीवार गिरने की आवाज आई तो मैं घर से निकलकर बाहर आए तो देखे कि मेरे भैया विनोद यादव पिटिशनर लिखो अमृत यादव, हरिंदर यादव, सुधीर यादव, सचिदानंद यादव, राम प्रवेश यादव, तुलसी देवी, मानती देवी एंड
एक सेकेंड, ये आप BA नंबर 1366 है?
Yes, 1366.
FIR केस 13 में है?
Yes.
ठीक है, ये दिनांक 27/10/2021, राइट?
27/10/2021 26 लोग
27/10/2021 देखिए तो FIR मैचिंग है दोनों का, चेक करिए। ये देखते मैच नहीं कर रहे।
Item 22 BA1383 of 2026.
FIR पहले रिजेक्टेड है आपका? पहले रिजेक्टेड है?
जी पहले रिजेक्टेड, ट्रायल के पहले आया।
कहाँ रिजेक्शन ऑर्डर?
शबने निवेदन को कहना है कि मैं सुशीला देवी उम्र 32 वर्ष पति मनोज सिंह ग्राम सोशो मेरे पति दो भाई हैं मनोज सिंह और दूसरा सुबोध सिंह। मेरे पति बाहर में रहकर काम करते हैं तथा देवर सुबोध सिंह घर पर रहते हैं तथा अपने पिता कृष्णा सिंह के साथ बराबर जमीन बंटवारे को लेकर
डायरेक्ट एलिगेशन है आपके ऊपर। There is direct allegation against you.
वो डायरेक्ट एलिगेशन
और bail has been rejected earlier also.
वो केस नंबर 24 क्रॉस एग्जामिनेशन वो लाइव टेस्ट उन्होंने साफ बोला है।
नहीं, आपका तो bail is rejected earlier.
घटना के वो आईडी टेस्ट नहीं है, घटना के तुरंत बाद मैं घटना स्थल पे पहुंची। घटना के
देखिए
5
एक बात
मिनट के अंदर
आपका bail application has been rejected by saying that petitioner is said to have shot his father over property dispute. The father of the petitioner succumbed to injuries. Right? उसके बाद क्या स्टेज चल रहा है? आप इसका अपील तो नहीं बहस कर रहे हैं ना? आप बताइए फिर क्या हुआ उसके बाद? किस ग्राउंड पे आपका कस्टडी हो गया, क्या हो गया, क्या नया ग्राउंड है? व्हाट इज द फ्रेश ग्राउंड?
वो ट्रायल एग्जामिनेशन के बाद गवाही के बाद जिसमें PW1 PW2 मतलब दो गवाह हो गए, बाकी कोई आई विटनेस नहीं। PW1 सिर्फ है उनके गवाह में पेज नंबर 24 उसमें कही है कि घटना के तुरंत बाद में घटनास्थल पे पहुंची, घटना के 5 मिनट के अंदर ही पहुंच गई थी, वहां देखी थी कि मेरे ससुर मृत अवस्था में गिरे हुए थे। तब मैं हल्ला करने लगी, हल्ला करने के तुरंत बाद कोई नहीं आया। जब मैं रोने लगी
कितने विटनेस हैं? कितने विटनेस हैं?
हाँ सिर्फ एक टोटल 6 विटनेस हैं जिसमें एक कोई भी आई विटनेस नहीं।
कितने एग्जामिनेशन हो चुके?
2 हस्बैंड वाइफ हो गए थे।
For the length constituting on behalf of the parties. The bail application of the petitioner was rejected by order dated 18/12/2024 in BA number 10705 of 2024. the counsel for the petition has submitted that he has renewed the prayer for bail by annexing the evidence of the witnesses, two witnesses during trial. He submits that none of them are the eyewitness to performance. He has also submitted that there are total 6 witnesses. Counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner. He submits that the witnesses will be promptly produced by the prosecution so that the trial is taken to a logical end. After hearing the learned counsel for the petitioner and considering the fact that there is direct allegation against the petitioner who is alleged to have sought his पिताजी को आए shot his father on property dispute who succumbed to his injuries. This court is not inclined to enlarge the petition on bail. However, the state is directed to ensure prompt production of witnesses. The counsel for the state is directed to communicate this order to the concerned authority to ensure compliance.
Item 23, DA.1391 of 2026.
नियम कार्यालय के आदेशानुसार कहना है कि मैं उल्लेख करूँ पिता सत्यसंध मैं राजनगर निगम राजस्व शाखा में कर कर्तव्य पद पर कार्यरत हूँ। मैं प्रदीप आपसी के द्वारा बिल्डिंग सेक्टर सत्यसंध वार्ड नंबर 30 लोटस गार्डन कॉम्प्लेक्स ब्लॉक बी को मेरे द्वारा जांच किया गया। जांच के क्रम में पाया कि उक्त अपार्टमेंट में इनके द्वारा निवास नहीं किया जा रहा है। इनके द्वारा होल्डिंग प्राप्त करने हेतु दिए दस्तावेजों की जांच की गई तो जाली एवं फर्जी पाया गया। आधार कार्ड डिजिटल पोजीशन लेटर अतः महादेव से अनुरोध है कि प्रतिपक्षी को सुसंगत धाराओं के तहत प्राथमिक दर्ज करने की प्रक्रिया। The petitioner was not named in the file of his name has transferred the supplementary charge sheet lordship. As per the MP order, the role of the petitioner has been explained lordship. Page number 32 lordship. Last line. There is a material that for last line. There is material for this way. That for obtaining the holding number, there was transaction between the accused auxiliary and accused person for paying 19,000 to Ankush Kumar. How that happened?
Just a moment. Page number 32.
32
He did heard the parties, yes?
Yes, sir. Heard both the parties, perused the case diary and supplementary charge sheet on such queries, it transfers that FIR by the accused case number such and date such and dot the police station Ranchi under section 420, 467, 471 IPC against Pradeep Ashi on the basis of complaint of one Sri Dilip Sharma tax collector Ranchi Municipal Corporation for submission of false paper, that is Aadhaar card, receipt bill and position letter of one flat number 101 Block B Lotus Garden Complex, Prajapati Road, Morabadi, Ranchi for obtaining holding number such and such. There is allegation that by creating a fake owner Pradeep Akshi of the property at Morabadi, which was under the position of Indian Army, it was sold to one company, Mrs. Jat Bandhu Tea State Private Limited. There is allegation that on the basis of the fake deed, accused them Azhar Ali played active role to obtain holding number in the name of Pradeep Akshi. There is material that for obtaining the holding number, there was transaction between the accused Azhar Ali and accused petitioner for paying rupees 90,000 to Ankush Kumar. During interrogation by the Ayuk, this Azhar Ali admitted over the transaction 90,000 for obtaining holding number. So, this is the confession of the two accused and the transaction that attempted 90,000 was involved for obtaining the holding from the RMC. That is the role of the petitioner. And these custody since
Pradeep Bakshi is an army person. ये आर्मी पर्सन का क्या काम है?
The land, the property which was transacted, that belonged to them. And the petitioner is custody since 28 2024.
क्या बोला?
But he has taken the active role in obtaining the holding that is observed and take holding on the basis of which the defense property or defense was sold undervalued consideration amount was sold with several of those it was highly undervalued and it was sold on the basis of the fake holding and there was a
On the
transaction.
basis of fake deed, this was sold.
Yes.
But what is the role of the petitioner?
It has come out in 33 for obtaining the holding lot from the municipal lot. There was a transaction between the accused Afsar Ali and the petitioner for paying ₹90 to Ankush Kumar. And Lord, Afsar Ali has also admitted this fact. Lord, that 98,000 was transaction was made for obtaining holding number. And this is the basis, Lord, on the basis of which the land of defense was sold. So certainly, Lord, all the documents was by the main accused Pradeep Bakshi, and in his name the property was holding number was given and paid ownership was created, and he has transferred the property to the that one police state that for the year for the transaction amount of 7 crore. And there is no whisper that during that transaction any amount I have received my account or any such allegation against the petitioner and the
Since when are you in custody?
28 2020
BSAT.
BSAT
State क्या है trial?
evidence
The learned counsel for the petition has submitted that as per the allegation, there was a creation of fake ownership with respect to the property in the name of Pradeep Bakshi, although the property was in possession of Indian Army. And by creating fake ownership in the name of Pradeep Bakshi, it was sold to Jat Bandhu Tea State Private Limited. And in the said transaction, the petitioner played an active role and an amount of ₹90,000 was paid by the petitioner to one Ankush Kumar. Who is Ankush Kumar?
So he has taken part as appears from the Q order that for obtaining the holding take holding, the transaction was made for 90,000 was to be paid to Ankush Lord that has been admitted by the Afsar Ali Lord that he has made a transaction of 90,000 for obtaining holding.
He submits that the petitioner is in custody since 28/2024 and the trial has commenced.
Mentioned para 16 or so and in the section that the state is evidence whether any examination of the witnesses
And the case is at the stage of defense. The learned counsel for the state has opposed the prayer and has submitted that petitioner is the main accused in the case in creation of forged holding number in connection with the property belonging to Indian Army. After hearing the learned counsel for the parties, and considering the allegation against the petitioner who is said to have been who is alleged to be the person instrumental in creating fake holding number in name of Pradeep Bagchi. This court does not incline to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses. The counsel for the state is directed to communicate this order to the concerned authority to ensure witness. Witness नहीं आएगा तब आएंगे.
But I have not created the first that is.
Witness नहीं आएंगे तो.
Item 24 PA 1390 of 2026.
Petitioner. Where is the petitioner? Petitioner absent. Goes tomorrow. एक बार डेट दे देंगे नहीं आएंगे तो ड्यूटी करेंगे.
Item 25 BA 1393 of 2026.
Allegation is that the group of extremists has fired upon the office of the informant and also damaged the vehicle of the informant. The petitioner is not named in there. And on what ground he has been arrested, I have not even explained the informant. Only one paragraph of the case diary was mentioned.
Case diary from criminalized. How many cases do you have?
From the order, it seems like 3 or 4 acts.
Alright, case diary.
Case diary with counter affidavit.
Case diary, counter affidavit, criminal identity. और डेट 7 April. स्टेट कोई भी हो गई कंसर्न काउंसिल को खबर कर देंगे. काउंटर फाइल करना है. कौन है वो अपीयर ही नहीं होते. काउंटर नहीं आएगा ना तो इसी यही कारण हो जाएगा बेल देने के लिए. ठीक है. कौन सा केस नंबर है आपका? सीरियल नंबर 25. कौन है काउंसिल में? काउंसिल फॉर द स्टेट इज नॉट present. However, Mr. Vishamba Sastry is present before this court. No. However, Mr. Vishamba Sastry, another APP, is present in the court, and he is directed to ensure to take instructions and file a contract in this case. Office is directed to bring the name of Mr. Vishamba Sastry. Office is directed to bring the name of Mr. Vishamba Sastry from the side of the opposite. आपका नाम रहेगा जी. आपका काम है वो फाइल करें आप करें हमको इससे कोई लेना देना नहीं.
Item 26 PA 12061 of 2025.
There is a contract. Why have you not filed your contract? You have received the case diary? कब 16 तारीख को? 16 तारीख को रख दे. केस डायरी में क्या आपको? पोस्ट केस डायरी में क्या आपको? And to file contract if so needed. He has got the case diary. Case diary दे दी. Counsel for the state has submitted the case diary to the court.
13, 18 and 19, he has cheated their lordship money, 80,000. That has
We'll
come
do it
here.
tomorrow. Case diary देखी. Just tomorrow.
Item 27, BA 12068 of 2025.
Yes.
Last check the order was that I counted also statement
Yes. Counter affidavit आ गया.
केस डायरी को है उनके ऊपर 43 पारण में इनके अगेंस्ट में सर एक क्रिमिनल एक्शन है, आर्म्स एक्ट का है.
इसमें इम्प्यूट ऑर्डर में मिली. केस डायरी या काउंटर क्या करेंगे? केस डायरी के बाहर काउंटर करेंगे. बताइए. Case diary has been received by the state, which has been submitted to the court. Goes to my. Take now next.
Item 28, BA 120 of 12079-25.
BA number 12079 of 2024. The learned counsel for the petitioner raised for withdrawal of this case. Permission is accorded. And this petition is dismissed as well. This petition is dismissed as well.
Item 29,
If you are
BA
parents, please.
12087 of 2025.
Where is the seat?
Because the petitioner is not in the FIR.
आपको काउंटर में फाइल करना है सर. अगला आप करा. किसको लेटर दिया? लेटर किसको दिया? हाँ? नोडल ऑफिसर.
Consular putting 180 granted bail on Sultan Judge Office.
नोडल ऑफिसर कहाँ बैठते? यहीं पर रांची में. हाईकोर्ट में बैठते नहीं. हाईकोर्ट में भी नोडल ऑफिसर हैं. कौन? BA number 12087 of 2025. The counsel for the state has submitted that in spite of communication to the nodal officer, he has not received any instructions, nor the case to file counter affidavit, nor the case diary has been received. इसका जरूरत नहीं आप अपने पास रखिए. Just a moment. However, time till 19th March is granted to the opposite party to file the counter affidavit by way of last indulgence. Post on 23rd. Page 7. Counter affidavit and produce the case diary.
Item 30, BA 12088 of 2025.
Official restriction 103, one of the and charge sheet was made under section 110 JS. In addition, ये सुसाइड का मामला है. सुसाइड का मामला है और फरियाद के अनुसार वो लोग 3 महीना मात्र रहे हैं साथ में. मैरिज का कहीं कुछ आया नहीं है और ये लोग केस डायरी में आया हुआ है और पट्टी में कि गुनार काफिल के घर में रहते हैं.
पढ़िए तो रहता है.
कोई क्रिमिनल
FIR पढ़िए.
पूर्वक कहना है कि मैं रवीना भी उम्र करीब 47 वर्ष पति स्वयं काम स्वयं खाना स्वयं जिला मुर्शिदाबाद पश्चिम बंगाल के निवासी हूँ। मेरी बेटी शहदा खातून उम्र 22 वर्ष पिछले 3 महीने से मुझसे थाना क्षेत्र के टिप्पी नगर निवासी स्वयं से पिता स्वयं रहती थी। मुझे 11 अगस्त 2025 को करीब 2 बजे सूचना मिली कि मेरी बेटी फांसी के फंदे पर घर में लटक रही है। सूचना मिलते ही मैंने अपने परिवार के लोगों को जानकारी दी और बल्लभपुर गांव पहुंचे। इतने में काफी संख्या में लोग मौके पर जुट गए। वहीं लोगों ने घटना की जानकारी पुलिस को दी। इसके बाद पुलिस मौके पर पहुंचकर घर का दरवाजा खोलकर अंदर गई। मेरी बेटी फंदे से लटक रही थी, जबकि उसका पैर जमीन पर पूरी तरह से सटा हुआ था। वहीं फांसी का फंदा भी सही तरीके से नहीं था, जिससे प्रतीत होता है कि मेरी बेटी की पहले हत्या की गई है और उसके बाद उसे फांसी के फंदे से लटका दिया गया ताकि लोगों को आत्महत्या का मामला लगे। वहीं साइबर से मेरी बेटी की हत्या करने के बाद साथ भी छुपाने का प्रयास किया था। मालूम हो कि 11 अगस्त की सुबह करीब 10 बजे मेरी बेटी शहदा खातून ने मुझे फोन किया था और बता रही थी कि मेरा पति शोएब से मुझे बहुत मारा है। वह मुझे रोज मारता है। आज सुबह से ही मुझे मार रहा है और बोल रहा है कि मार के फेंक देंगे तो क्या होगा, मेरा कुछ नहीं होगा। महोदय, मेरी बेटी को हमेशा उसका पति
Call for the case ID and including the
इसमें
postmortem.
केस डायरी कहाँ से?
कहाँ है case
केस
ID?
डायरी कौन हुआ था?
कहाँ है? Where is the state? और कब से कस्टडी में है?
कस्टडी में हम 13/8/2025
चार्जशीट हो गया है
चार्जशीट।
तो केस डायरी तो कोर्ट में होना चाहिए ना, मंगाते हैं वहीं से। स्टेट तो है ही, उनको तो कोई मतलब नहीं। पोस्टमार्टम रिपोर्ट बहुत जरूरी है ना।
हाँ।
अभी चार्जशीट आपका हुआ है।
पोस्टमार्टम रिपोर्ट आया है ये
कहाँ है?
कोर्ट में दिया हुआ है। Postmortem report of the victims of the case, the cause of her death was due to CRA due to SCC.
चार्ज फ्रेम किसने हुआ है? चार्जशीट किसी ना होने से थोड़ी हो जाएगा। चार्ज किसने फ्रेम हुआ है?
इसमें है
पोस्टमार्टम रिपोर्ट में असॉल्ट है? नहीं पता। In spite of order passed by this court dated 13/2026, neither the case diary has been produced nor the counter affidavit has been filed, and nobody is obtained on behalf of the state. Counsel for the petitioner has submitted that the charge sheet has been submitted before the court. Office is directed to call for the case diary from the court concerned, which should include the postmortem report. If the charge has been framed, the order framing charge should also be produced. Post on 7th April.
Item 31, DT.10.03.2026.
Who is your senior counsel?
Mr. Anil Kumar Madhav.
Direct allegation. What is the stage of the crime? I just
Trial likely to be concluded very soon.
it is at the fag end, only one witness is to be examined. Trial for conclusion, 21 to 26. Yes. Counsel for the petitioner seeks adjournment. At her request, posed this case on 13th of April. As per the report received from the concerned court, only one witness was remaining to be examined. The office is directed to call for a fresh report regarding the stage of trial, which we sent on 8th of April. रिपोर्ट 8 अप्रैल का देखेंगे, हो सकता है तब तक सब एग्जामिन हो जाए. 13th April.
Passport case from supplementary list item 1, DA.10.01 of 2025.
Prisoner in custody in the cyber case, one and one mobile was recovered from him, along with 5 others.
Along with 5, altogether 6 mobiles.
6 persons were arrested and mobiles have been recovered, one has been recovered from him. 2 of them have already been granted bail by the coordinate bench of this individual, and there is no criminal antecedent against him.
Yes, please. क्या बोलना है आपको? Page number, para number?
77.
77. There is one victim also in your case.
Please just have a look to the order in the case of Hasmudi. petitioner has been in custody since 1/9/25 and has no criminal antecedent, as has been mentioned in paragraph number 22 of the bail application, and the petitioner has only cheated one victim of rupees 2,598.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition has submitted that the petition is in custody since 1/9/2025 and one mobile has been seized from the two mobiles are.
Please just submit with me. First information report. One green mobile. That is at page number 17. Page number 17. 10-12 lines from the bottom. Third, अल्वी हरिदर के पास से लाइट ग्रीन वाइबो एंड्रॉइड मोबाइल IMEI नंबर सच जिसमें जियो सिम मोबाइल नंबर
एक मोबाइल का दो IMEI नंबर.
Yes, that is the and SIM mobile number is only 10.
And we have submitted that the petitioner has no criminal antecedent. He has then submitted that two co-accused persons, namely Vishnu Kumar Das and Hasnuddin Ansari, have been enlarged on bail by coordinate benches of this court in BA number 11338 of 25 and BA number 10862 of 2025 respectively. The learned counsel for the state has opposed the prayer and has submitted that as per paragraph 77 of the case diary, there is one victim who has supported the case of the prosecution as against the petitioner, whereby she has been looted for 18,000 rupees. कितना amount है? ₹18,000 कट गए ना? है आपके पास? Has been looted for 18,000 rupees and she has also reported the alleged offence online through online complaint. To this, the counsel for the petitioner has submitted that even Hasnuddin Ansari had cheated, is said to have cheated one victim to the extent of rupees 4,598, who has been enlarged on bail. After hearing the learned counsel for the parties and considering the fact that the petitioner was apprehended on the spot with mobile and two with mobile and while committing cyber and has been alleged that he has committed cyber offence and one victim has also lodged a complaint against the petitioner. This court is not inclined to enlarge the petition on bail at this stage.
Serial number 30, state.
I said he will do this.
So case from Daily List item 7, DA.12.06.8 of 2026.
एक केस में उन्होंने अपीयरेंस लिखवाए हैं सीरियल नंबर 30 में गौतम राकेश सर अपीयरेंस दिए हैं तो क्या करें?
नहीं ऐसे अपीयरेंस नहीं ले सकते, ऐसे अपीयरेंस नहीं ले सकते किसी का। The SIM cards and mobiles were in names of forged identity.
No, on my name.
On your name?
Yes, ma'am.
Should I record it?
Only one.
It has been wrongly mentioned. The SIM cards found in these mobile phones are alleged to be obtained on the basis of forged documents of identity in the name of different persons and the allegations of forced transaction from several accounts illegally.
It is for all the accused persons. There are 3 accused persons.
So far as your mobile is concerned, it was in your name. Should I record it?
I have stated, that's why my daddy has not.
Where have you stated that the mobile seized from you, mobile and SIM which has been seized from your possession is in your name? Where have you stated?
That I have not stated.
Then?
It was of all the accused persons with common.
So how do you make such a submission? Personal knowledge है आपको?
नहीं, personal knowledge.
So कहाँ से बोल? That the mobile app which has been recovered and the SIMs are all in your name and still you have been made accused in this case. From where are you saying this? नहीं नहीं गलत सबमिशन को हमको बहुत हमको गुस्सा क्यों देखें हम डायरी आप कहाँ से बोल रहे हैं where have you from there has to be some material to make this statement from where are you saying this
Because my iPhone mobile only
from where are you saying this
only one mobile phone SIM has been recovered from the possession of this petitioner.
that's right but it is in your name from where are you saying this show me some material
अब सो कल मैं इसमें डैडी ने देखा
डायरी है आपके पास
some of the parts of the daddy's there. ऐसा होने का कोई उसमें रोशन में डैडी को
किसका ये नंबर
ये नंबर 1067 of 2026.
इसका नेक्स्ट डेट
24/2026.
it is on 2/4/26
Next date my Lord Rosham is 24/2026.
also for the petition submits that case ID in connection with the co-accused has been called for in BA number 1067 of 2026 and the next date fixed in that case is 2/4/2026. Let this case be placed with BA number 1067 of 2026 on 2/4/2026 to be taken up together.
Password case item 21, BA 1306 of 2026.
the fire will work for the officer section 414. The case 13 of the prosecution.
Page
13. Where? उपरोक्त विषय के संदर्भ में साबित सूचित करना है समय पत्र लिहाज के पास अपना स्वीकृत बयान अंकित करता हूँ कि आज सूचना मिली कि सागर एवं विनोद यादव उड़ीसा से चोरी का एक पोकलेन मशीन लाकर किशोर यादव पिता स्वयं जिले को घर पर रखे हैं तथा बाहर ले जाने का प्रयास में छापामारी करने में पकड़ा है। इस आशंका थाना बैंकी ने प्रदेश के बड़ी पदाधिकारी को सूचित करते हुए सूचना सत्यापन में आवश्यक कार्रवाई मैं थाना पर उपलब्ध बल के साथ सरकारी वाहन से प्रस्थान किया तथा स्थानीय चौकीदार स्वयं को सतर्क किया। समय 12:35 बजे ग्राम सलेट पुलिस स्थान स्वयं को लेकर पहुंचा तो पता चला कि पॉपुलर मशीन बैंक ऑफ इंडिया पटरिया शाखा के बगल में इसके फिलिंग पेट्रोल पंप के पास रखा गया। जब इसके फिलिंग पेट्रोल पंप पटरिया के पास पहुंचा तो पाया कि एक पीला रंग का हुंडई कंपनी का बिना नंबर का पॉपुलर मशीन इंजन नंबर उसके बाद नंबर मिटा हुआ पेट्रोल पंप के पास रखा हुआ जहां चौकीदार महेंद्र सिंह एवं अन्य ग्रामीणों के द्वारा बताया गया कि उक्त पॉपुलर मशीन विनोद यादव ढाका एवं सागर तथा किशोर यादव सलैया पुलिस गाड़ी के द्वारा लाकर कहीं ले जाया जा रहा लेकिन भाड़ा का जुगाड़ नहीं होने के कारण ट्रेलर पर से उतारकर पॉपुलर मशीन को रखा गया है जो आप लोग को आते देखकर किशोर यादव विनोद यादव सागर पॉपुलर मशीन छोड़कर भाग गया। उक्त पॉपुलर मशीन को उपरोक्त तीनों लोगों के अलावा अन्य के द्वारा उड़ीसा से चोरी कर लाए हैं जो अन्यत्र बेचने के लिए ले जाया जा रहा है। उक्त पॉपुलर मशीन का चेक करने पर कोई कागजात नहीं मिला जिसके उपरांत स्थानीय लोगों के द्वारा जब्ती सूची के जवाब आने से इंकार करने साथ गए सशस्त्र बल के स्वयं बिना रंग का हुंडई कंपनी का बिना नंबर का पॉपुलर मशीन जिसका इंजन नंबर उसके बाद मिटा हुआ तो विद्युत जब्ती सूची बनाकर जब्त किया। अतः उड़ीसा से पॉपुलर मशीन को चोरी कर बेचने के लिए जाने का आरोप में किशोर यादव स्वयं विनोद यादव पिता न मालूम पिटिशनर रिपोर्ट सागर पिता न मालूम अन्य धारा 10 करता हूँ थाना लौटने पर औपचारिक प्राथमिकी की जाए। तो पॉपुलर मशीन हैज नॉट बीन सीज्ड फ्रॉम द
फोर्ज डॉक्यूमेंट का क्या है? Petitioner has prepared a forged document.
Come on that point first. Initially, the FIR has been lodged on the basis of the information given by the villager. And during investigation, the Sagar Sakil produced an agreement which was executed between the one. I have mentioned in that petition also. Between Khan in favor of one beliefs, and the petitioner is only the witness to that agreement, and on that basis he has been impeached. And the said Sakil has already been granted bail by the coordinate bench of this honorable court, and for commission of theft regarding commission of theft also, for another case, Govindpur case number 168 of 2021 has already been lodged. In which Oakland has already been released on.
So you have been enlarged on bail in that
case? In such case also. I have an next.
When?
Annexure 2 case. That is for commission of theft of the said problems.
Same problem.
Yes.
क्या बोलना?
इस ऑर्डर में क्या है?
डायरेक्ट एलिगेशन क्या है? विलेजर्स का कहना है कि वो लेके जाए। और चलने का स्टेज क्या है? कस्टडी कितना है?
कस्टडी 2011 to 2025 कॉम्बिनेशन हो गया।
Or the learning council appearing on behalf of the parties, the council for the petition submits that the petition has been made accused as per the FIR on the basis of allegation made by co-villagers that petitioner was seen along with the propylene machine he submits that the co-accused lady Sagar alias Sakif Khan, who is similarly situated at that of the petitioner, has been enlarged on bail by a coordinate bench of this court and the petitioner is in custody since 2011-2025. He has also submitted that a separate case was instituted in connection with the same vehicle in which the petitioner is an accused and has been enlarged on bail on 27/1/2026 by the concerned court. The learned counsel has also submitted that the co-accused claimed that the proclaim machine was sold to Dilip Singh.
Yeah.
And it is alleged that the petitioner has signed as a witness
Yes.
in that agreement. And the state document has been found to be forged. You have criminal antecedent also.
वही केस है अब लिखे हैं
The learned counsel submits that apart from the aforesaid two cases, there are no other cases against the petitioner.
as
The learned counsel for the state has opposed the prayer and has submitted that the petitioner is named in the FIR. After hearing the learned counsel for the parties and considering the fact that the petitioner who is an accused in another case relating to the same vehicle has been enlarged on bail, and the co-accused in the present case, namely Sagar Khan, has also been enlarged on bail by coordinate bench in DA number 10161/25, and the charge sheet has already been submitted. Cognizance has been taken on cognizance has been taken and submitted by the counsel for the petition. The petition is adequate to be enlarged on bail.
From supplementary list for orders item 3, first of 209/2025.
IA number 334/25 has been filed seeking extension of time to comply with the order dated 21st of January 2026.
But because of want of direction, it's not been accepted.
The counsel for the petitioner has submitted, the appellant has submitted that due to inadvertence, the requisites could not be filed on time, and when they approached the office to file the requisite, they did not accept it on the ground that the period granted by this court has expired.
All the filing of that requisite have been done. It has been filed, but it has not been accepted. So
He submits that the requisites have already been filed, belated.
Yes, sir. Yeah.
Considering the submissions, the time for complying the order dated 21st of January 2026 is extended, and the next date fixed in the first appeal is modified and is directed to be on 8th of April. Office is directed to immediately dispatch the notices fixing the next date as 8th of April. Post on 8th April. Date is come out. Are you post?
For hearing on order 41/11, item 6, second appeal 190/2025.
Application for nomination of PA and asking for second
there is some merit in the appeal, then only we should issue notice. Some partitions the plaintiff paid for 1/3 share in suit property. Suit was repealed. The defendants contested the suit by specifically saying that there is no joint family fund or purpose to which the family property is purchased. In fact, the plaintiff witnesses have also said that they were separate in Western residence and they had no connection with the family of Mangal Singh. Yet the suit was repeated only on the ground that the sale contained names of the three persons. On appeal, you are likely to find that there is absolutely no consideration of the evidence.
The sale deed contains the three purchasers. Then how do you discard that?
There is, if I can take your leadership to the evidence of the plaintiff witnesses themselves.
No, I just want to know, when the sale deed is in name of three persons, how do you discard that?
But there has to be the payment, the amount, the payment of consideration has to be shown that all the three of them have contributed.
The payment of consideration is reflected in the sale deed. Does it show that only one person has contributed?
There is an admission that the draft was prepared by Mangal Singh. There is an admission in evidence. And the first appeal could really
Mangal Singh and other co-owners are the...
Mangal Singh, yeah, did the defendants...
How are they related?
Mangal Singh, there were two brothers, Ishu Singh and Raja Singh. So Ishu Singh had two sons, the plaintiff and Sitaram Singh. And Raja Singh's son is Mangal Singh. So they were not even first degree cousins.
So you want to say it's a Benami transaction?
It is the pleading and the evidence on record shows that since the property is a big property, so therefore Mangal Singh, who was a contractor, he included the name of his cousins.
But they did not pay any.
They did not pay. There is an interrogatory application also for additional
There is a
substantial.
finding that there is nothing in the sale deed to show that Mangal Singh had only paid the consideration.
But there is admission in
Whose admission?
PW.
Whose admission? Mangal Singh. Mangal Singh has been examined.
Mangal Singh's no. The suit was instituted after his death. During his lifetime, there was no.
Okay. The payment was cash?
Draft.
Draft.
And ladies, if I can take the relation to the evidence, just one.
Draft from whose account? Mangal Singh's account. That is not enough. That is not enough. You are claiming
by the plaintiff himself that Mangal Singh had prepared the draft, and they say that I cannot show anything that I had paid because he is not even an income tax free. The plaintiff himself says I am not an income tax free.
Does it say that? Is there any law which says that only an income tax payer can purchase a property?
Therefore, there has to be some capacity to pay the consideration amount.
See, you are primarily claiming a Benami transaction. This is what it is.
May not be Benami in sense.
Benami.
But there has to be some appreciation of evidence by the applicant.
No, there has appreciated the evidence.
No, there is no as your mentioned anything.
You see para 15. Rather, finding starts from para number 14. See?
But can I take a leadership to the trial court judgment and just pinpoint the evidence which ought to have been considered?
Which paragraph is that?
Yes.
Whose evidence?
Plaintiff.
Okay, let
Richmond, can you come to para 64?
It's a judgment of concurrence.
Para 64. Towards the middle and Mangal Singh came to Ranchi in 54, whereas he came in 68. Mangal Singh was a driver in construction company and later became contractor in PhD and purchased 4 trucks. When he came to Ranchi, he started working with Mangal Singh, who used to give him a share but no percentage of success. He used to support family in village with farming and money which he used to get from Mangal Singh. He started getting paid after 1 year of his arrival in Ranchi. He does not remember how much money he used to get, but it was sufficient to maintain his family and system continue till life of Mangal Singh. He also admitted that Sitaram Singh came prior to him in 57, 58, later in cross-examination, para 66, he admitted that Sitaram Singh came to Ranchi in 71. In para 69, was cross-examination, he admitted he opened bank account in Indian Overseas Bank some 15 years ago. Sitaram Singh opened bank account prior to him in State Bank in Ranchi. He also admitted that he is not an income tax free. In his cross-examination para 74, he gave 33,500 to Mangal Singh. Regarding source of money, he stated 30,500 rupees to Sitaram Singh, 33,500 rupees to him, which his father gave from farming loan. His father died in 88. His father has around 20 to 25 bighas land in Shell. Mangal Singh also owned truck, a brick kiln and petrol pump in name of his deceased son Ashok Singh. He further stated that he got a shop in the Soot land where he runs a photocopy and stationery shop since 87. But he cannot produce papers regarding purchase of photocopy machine. He has admitted that he has no documented proof of giving money to Mangal Singh. He admitted that he has no documented money. He has further stated he is karta of his own family. Sitaram Singh was karta of his family while Mangal Singh was a karta of his own family. They all used to maintain their individual family from their individual income. He has no concern with bank account of Mangal Singh, and similarly Mangal Singh has no concern about bank account, and the same was the fact with Sitaram Singh. He has also admitted the payment of concession amount was made through bank draft which was procured by Mangal Singh.
That's right, but he is also saying at the same time that he paid money to Mangal Singh. We need not have documentary evidence. Is there any cross-examination on that?
Yes, this is cross-examination.
No, you see,
this is cross-examination.
Just a moment, he has made a specific statement that he paid 33,500 to Mangal Singh. And he was an employee of Mangal Singh and he was getting money from Mangal Singh and he was maintaining his family from that money.
Maintaining his family, but he did not say that.
In second appeal, it is difficult.
Leadership, at least these evidences ought to have been considered. There had to be some discussion. Some discussion. The appellate court is absolutely silent on these.
This is the discussion of evidence of
PW1, that PW2 is also there.
This is PW1.
This is PW. You can rely upon the judgment of report. Applies for 41 to 31.
It requires framing of a substantial question of law, but that will be done only after the delays. I think that is the law. It requires framing because they are saying that they have their own independent income, they are separate units, and the judgment says that it's a joint family fund. IA number 17255 of 2025 in SC number 193 of 20. IE number 17209 of 2025 in SC number 193 of 2025. Let notice be issued to the respondents in the interlocutory application seeking condemnation of delay for which requisites through speed post be filed within a period of 1 week. How many?
There are 5 months.
Within 10 days. Another interlocutory application being ID number 17255 of 25 has been filed for suggesting further substantiation of law over and above what has been suggested in the memo. The proposed additional substantiation of law will be considered at the time of at appropriate stage IA closed. Up limitation penalties. Pose this case on 28 call for LCR. कॉल पर LCR कर ले छोड़ दीजिए आने चलो 28
Out of turn mention case from bail is item 69, first appeal table 2 of 2023.
Joint all the parties have see, the point is that you have filed your joint compromise. Only one is the signatory over here.
For the purpose of affidavit, because I've annexed the agreement in the annexure, it's the agreement which has been drawn, all the parties have signed independently. Just for the purpose of filing an affidavit.
You see, whenever a joint compromise petition is filed, either you file an affidavit.
We have filed a counter annexing the same document.
Where is that counter? When did you file it?
We have also filed the same.
$310.25.
Yes. By way of counter affidavit on behalf of respondent. The document which they have annexed through IA, we have also filed through counter. That is the agreement.
Who is the respondent number 2? How is he related to respondent number 1?
All three are brothers. The appellant is the elder brother. Rest all.
Michael's will kindly draw attention to page number 19 of my IA. We give a clear picture of this. Page 19. All the son of Muhammad Israel. Page 19 of my IA. प्रथम पर तृतीय पक्ष all the son of Muhammad Israel.
Respondent number 2 का नाम क्या है?
तस्लीम आरिफ है शमीमा.
Shamima.
Yes.
He is also party to this.
Yes.
IA number 14945 of 25. It was appeal number 222 of 2023. The Learned Counsel for the appellant has submitted that the interlocutory application has been filed, bringing on record the compromise entered into between the parties, which is in the form of a Batwara Nama, in bracket family arrangement, and has been annexed as Annexure 1 to the utility application. The Learning Council for the respondents has submitted that the two respondents are full brothers of the appellant, and the case arises out of a partition suit. And they have also filed a counter affidavit annexing the same compromise petition. Same but Paramnama / family agreement. The councils have jointly submitted that the appeal be disposed of in terms of the compromise entered into between the parties. And the but Paranama / within bracket family arrangement may form part of the decree. After hearing the Learning Council for the parties, it appears that the parties have settled their dispute outside the court. The case arises out of a partition suit in which there are only 3 parties and all of them are full brothers. In such circumstances, this appeal is disposed of in terms of a compromise. Annexed as Annexure 1.
Annexure 1 monuments have also translated the terms of compromise from para 9 onwards.
That may be recorded.
Para 9 onwards is the compromise terms of who will get what share of property.
There is a map also around page 15.
If this Batwara forms part of the, that should be enough.
That would be definitely for minor convenience. The terms have also been drawn in English.
At this stage, counsel for the appellant has also submitted that the terms of compromise has also been translated and has been mentioned in
para 9, 10,
paragraph 9, 10,
11,
12,
12
of the interlocutory application, which are quoted as under. Khali quote करके this appeal is accordingly disposed of in terms of the compromise as contained in Annexure 1 to the interlocutory application. Are you disposed of? If you also disposed of in terms of office to prepare.
From supplementary list item 4, second field, 1123 of 2022.
He had purchased the property in the year 1954 and 10 point something odd acres of land that was required by virtue of for personal land. This is the nature of it. Because of my father he used to render service to
on the date of the bill, the settlement was not made.
So he issued a bill in the year 1957 and thereafter the Pashupatinath Malia he died way back in 1969. And my father also, he also issued a bill in the year 1973. But so far as our case relation is concerned, that we came in possession by virtue of that bill, and by virtue of perpetuity of possession, we have acquired it. Is it what
you are claiming adverse possession?
But my claim will achieve the perpetuity of possession. And
what else? You are claiming adverse possession?
Yes. And we are in possession also. But so far as the point of possession is concerned, but the learned trial could presume and only on the basis that the other guy and their father used to visit the property, so that he presumed their possession. And the learned appellate court, without making any discussion of the oral evidence, had said that they are in possession. That the entire
the point is that you are claiming title on the basis of prevailing.
Yes. But
it has not been probated also.
Yes. And they were not so far as the probated.
Can you claim title on the basis of the
letter of administration has been filed before the court. That was dismissed against which a miscellaneous appeal is pending before this court, which has already been admitted. This is also a factor which is required to be considered.
MA number?
MA number your should be.
If you ultimately lose in that MA, you have not title.
Not if the MA is allowed, then I have everything. That's what is the judgment of the FS court also in Supreme Court. The Lordship may kindly see this judgment. The Lord may kindly see this judgment.
इसका next date बताइए MA 232 of 2019.
Yes, the Lordship may kindly see.
232 of 2019.
This judgment your Lordship may kindly see. The Lordship may kindly see, Para 27. My Lord, may kindly see. Scrutiny of long catena of cases reveals that this court has consistently taken a view that an unprobated bill can in fact be looked into a court for the purpose of construction or for any other political purpose. In the case of Sir Davi versus Mahendra Donath, reported in such and such into testated empowered stated fact. Next paragraph I would like to see.
On the date of the bill, the settlement was not made.
Well,
on the date of the bill, the settlement was not made.
But your Lordship, the person died in the year 1969.
Must have. Settlement is of 1961.
No, settlement, the application for settlement was given in the 54.
That's right. But the settlement happened in 1961.
But your Lordship,
the bill was executed in 19.
My Lord, may kindly effect of bill only comes when a person dies.
That's right.
And so far as during, even if had been in his name, had it been even in his name, then my Lord, it will not my Lord, have any effect. And because the bill is the document, which only comes my Lord, after the death.
There is a substantial question.
Yes. Your Lordship, I would be Lord, giving my Lord some rearranged question. First substantial question of law is whether the finding of the learned appellate court that the plaintiffs are not in possession over the property by fire, as they remained all along in possession after death of their father, that Amit Khan, who was appointed tutor by the Pashupati Nath Malia, while will dated 25/11/57 and have acquired right at his interest by virtue of perpetuity of possession. Whether the learned appellate court committed malversity in recording finding that the defendants are coming in possession over the suit property despite admission of the defendant that the plaintiff's father remained in possession of the suit property, and the caretaker and observing that the plaintiff remained in possession for more than a statutory period of the 12 years. Whether the appellate court committed malversity in discarding bill dated 25/11/57 exhibit
Exhibit 1 without appreciating the true purport of Section 213 of Indian Sanction Act. It does not bar.
Your status was that of a caretaker. Your status was permissible.
Yes, and the learned trial court has framed this issue and has taken into consideration that whether my position is as a permissive position or as an owner. But my lord has said that I am not in position. How it can be? If the moment my lord the court says that my position is either it can be permissive or my lord as an owner, then meaning thereby I am in possession. There cannot be a finding that I am not in possession. What would have said, no, your position is not a valid position, your position is a permissive position. I could have understood that. And my lord, the total bill it has discarded, has been discarded, my lord. But taking into consideration, my lord, the letter of admission dismissal, which again, this my lord, appeal is already pending. I have read this question also. And one more important point, Your Worship. The appellate court has not taken into any oral evidence in consideration. But the trial court has taken into oral consideration, oral evidence, to come to a finding that their fathers and even after death of fathers, the defendant number 1 and defendant number 2 used to visit.
At the time of passing the appellate court's judgment, the judgment in the probate case was passed?
Yes, that is Exhibit G.
They have considered that.
They have considered that. So that's why I have framed this issue. So once the dismissal has been taken into consideration, admittedly, but if the appeal is wrong, I have everything that part of the judgment which I have assumed. So it has a bearing in this case. And it has already been admitted for this.
The learned counsel heard the learned counsel for the appellant. Submits that the plaintiffs were claiming the property on the basis of a will.
Position. Basically, my case is of position. The will by virtue of will I have come into position.
Was claiming the property on the basis of possession and will, dated 25/11/1957. He has submitted that the probate case was dismissed, which has been admitted in by MA number 232 of 2019. Order dated 16 February 2023 and is pending before this court. The learned counsel has further submitted that the findings recorded by the first appellate court while dismissing the appeal suffers from non-consideration of oral evidences adduced by the parties. And he also submits that the same has serious bearing with respect to the possession of the plaintiff. He submits that it was the specific case of the defendant that the plaintiff's father remained in possession of the suit property as caretaker, and therefore the possession of the plaintiff.
And after his death, we are in possession.
And after his death, the plaintiffs remained in possession. He submits that in view of the clear stand taken by the defendant, it cannot be said that the plaintiffs are not in possession of the property. The following substantial question of law yes, the Learned Council has placed on record has filed considering he has also submitted that the order in the probate case has been taken into consideration and which is Exhibit G, which is now pending in MA number 232 of 2019. He has also submitted that after hearing the counsel for the appellant, the subject is awaiting for final hearing on the following substantial questions of law. कौन सा बना है?
Perversity से related
One और D बना देते हैं. D बना देते हैं.
B इन्होंने ये वर्ड कर दिया है कि वो पोजीशन में और वो भी बिना कोई एविडेंस को ओरल एविडेंस को कंसीडर किए हुए कि अभी अब C और D भी इम्पोर्टेंट है. D and E को मस्ट है.
D and E कर देते हैं बस.
परवर्सिटी पर एक पोजीशन पर बना दिया.
ये तो पहला वाला बनाएंगे. A, D and E. At this, the counsel for the appellant has submitted that it would be better if this appeal is tagged and heard along with MA number 232 of 2019. Since the miscellaneous appeal is not assigned to this court, office is directed to place this order before the Honorable Chief Justice so that both the matters are put together. Issue notice to the respondents for which recusals under speed post be filed within 10 days. कोई अभी आपको डेट नहीं देना. डेट तो देना पड़ेगा ना. Post on 30th. Let the record be called for. Second.
Item 5, surrender CT5 of 2023.
In this case, originally when the suit was filed by the respondents, we were the defendants. That was dismissed, pending appeal. The matter was remanded back and liberty given to the examined other witnesses, and therefore the appeal, the suit was decreed and the appeal has been dismissed. So the case is the plaintiffs claim that title through one Nanu Mathur. And as per the documents made by them, there was a settlement in favor of Nanu Mathur for 12 years. So that stands mentioned, that settlement document has not been produced by the plaintiffs. That stands mentioned in the Khatiyar and the Khevat which has been exhibited by them. So in our case is, after the expiry of 12 years, the landlord came back in position, landlord made a settlement in our favor in 1940, followed by continuous issuance of rent receipts. Subsequently, when you look at the fresh proceedings under section 83 C80 was going on, also the respondents filed an objection. That was rejected. They filed a revision in 1984. That was also dismissed. But once that order of settlement becomes a order of recording of rights in Lordships of preparation of record of right becomes final, Lordship, that is cannot be a subject matter of a suit, and there is a bar of suit under section 92 of the same year. Lordship, 2001 they filed a suit seeking declaration of right title interest and recovery of possession if they are found to be dispossessed. Our objection was that firstly it is barred by limitation. For the reason, rightly wrongly also there was a settlement in our favor in the year 1940. But they have produced in order to explain the limitation that there were certain rent receipts issued in their favor in different years. 6 in number they have produced. The learned court will explain the limitation by saying that as rent receipts were issued for certain periods in that time, therefore it is not barred by limitation. But while doing so, the learned court below records are finding that your lordship, that 1940 settlement in our favor cannot be legal for the reason that in 1935 record of rights, it is mentioned that settlement in favor of the predecessor and in interest of the plaintiff were for 12 years and that would expire in 1947. That was a complete misconceived finding by the learned court. For the reason, 1935 Lordship Hathiyar do not say that settlement of 12 years is from 1935. It only records that they are in position B of a settlement for 12 years.
It is recorded in 1935.
In the record of in the Hathiyar of 1935, it is mentioned they are in possession as a also on the basis of settlement for 12 years. Court will presume that 12 years will start commencing from 1935 onwards. Suppose wrongly, Lordship, they have been removed and we were given in position in 1940. Your suit in 2001 will become time bar. The issue as to the validity of my settlement cannot be looked into, Lordships. And most importantly, Lordship, when they had gone up to revision, Lordship, by filing a revision under section 84, Lordship, with respect to their objection which was rejected in a proceeding under section 83. The
suit is not barred. If it is a title suit, it is not
title
barred.
suit, Lordship, where the Lordship indirectly the validity of that order is under challenge. And that too, Lordship, they lost in the year 1984. If you Lordship just comes to page 29. Lordship, can you come to suppose the documents of the evidence? Lordship, can you come to exhibit E by 1? Certified copy of the revision case number 208 of 1984 by which the petition of Ardali Hussain was rejected. This was an objection. Lordship, revision file against the rejection of objection under section 84. And that became final in 1984. Secondly, Lordship, can you come to exhibit E by 2? Photocopy of the appeal filed by Ardali Hussain by which it was held that position of Ardali Hussain was not found. Thereafter, Lordship, can you come to exhibit F and G? Lordship, part of the land was acquired by the state government. In the land acquisition proceedings also, Lordship, the compensation was decided in our favor.
What is the substantial question?
The substantial question of law is one of the substantial question of law is whether the Lordship suit was on the face of it barred by limitation. Secondly, Lordship, take into consideration that whether the plaintiff could have Lordship conveyed a title, the predecessor in the interest of the plaintiff could have conveyed a title better than what they have. The admitted case is Lordship, as per the own document of the plaintiff, the settlement of their predecessor in interest was only for 12 years. So they cannot convey a better title than what they have. And thirdly, Lordship, question number Roman question number 2, Your Lordship.
So you want 1?
1, 2.
And Roman question number 4. And one relative which we have
Who
taken
settled the same in favor of the predecessor in interest of the plaintiff?
the landlord admittedly relative, they both go in the relative when the matter was remanded.
You are the defendant.
I was the defendant.
Yes.
Oh, no, one Nanuma, in whose favor there was a settlement of 12 years by the same landlord who had settled in our favor.
So you have said that who subsequently settled the same in favor of predecessor in interest of the plaintiffs. Paragraph Roman 2.
It is ex-landlord subsequently settled.
Yes.
Whether in view of the period of expiry of the settlement of possession of property in question, resumed by the ex-landlord who subsequently. Original ex-landlord is common relative. He settled in favor of Nanu Mato for 12 years.
That's right.
And after expiry, that same landlord settled it in our favor.
ये क्या लिखे हैं आप? In favor of predecessor in interest of the plaintiffs.
Dependent.
The rent receipt have been issued in favor of the plaintiffs, not
Yes.
in your favor.
No. And it's our has also been exhibited. Actually, can come to
You just have one rent receipt. Where is the order of section 5, 6 and 7 of Bihar Land Reform Act? You come to page number 33.
Page?
33. You just have one rent receipt.
No, it's
yes,
CD.
No. And the plaintiffs have several rent receipts of different years.
Yes, 5, 6 rent receipts. Without any, can you come to the list of exhibit which I was showing? Can you come to exhibit C and D?
Exhibit C is only one rent receipt. Exhibit D is just one rent receipt.
And therefore also the section 83 was decided in our favor.
That is a separate thing, but you have only one rent receipt.
Yes.
Isn't it? You claim
And
settlement through what process?
And also their rent receipt is, defendant's rent receipt is after 75 deeds. All dated after 75. Their predecessor in interest did not have any rent receipt in their favor.
No.
Yes.
Plaintiffs have several rent receipts of different years.
Also after their predecessor in interest, if I am the owner, if I transfer it to him, there should be some rent receipts in my favor. All rent receipts, lots of 6 rent receipts are filed in the name of the plaintiffs, not their predecessor in interest, not a single rent receipt. Rent was never fixed in his favor. And lots of some of the rent receipt is subsequent to the order passed under section 83. Apparently without jurisdiction.
सेकेंड हाफ में ऑर्डर आप ही का तो फर्स्ट केस है उस समय ऑर्डर
छोटा एक्कोमोडेशन एक टिपिकली मेरा एक ही केस का पेपर है नहीं
तो हम आप नहीं रहेंगे तो भी हम ऑर्डर लिखाएंगे उसमें क्या दिक्कत है इसका ऑर्डर तो लिखा ही सकते हैं आप तो सुनिए
उसमें भी आर्गुमेंट कर लेते हैं तो दैट डीटी सिटी मनी फॉर